this is Renee Kuhs, Compliance Attorney with H&I. We put together this brief summary of the status of healthcare reform as it is after the Supreme Court's ruling. Healthcare reform was originally signed into law in March 2010. Since that time, it's almost impossible to turn on the TV or radio and not hear some debate about healthcare reform. It is a hot topic that impacts every American. On June 28, 2012, the Supreme Court issued its ruling on healthcare reform. Since that time, a renewed energy surrounds the debate on healthcare reform. Even several days following the ruling, you cannot escape the endless discussions that are taking place 24/7 in all forms of media. The U.S. Supreme Court agreed to review the healthcare reform law to determine whether it was constitutional. On June 28, 2012, it issued its opinion. The Supreme Court upheld healthcare reform with a 5-4 vote. Much discussion surrounds the surprise that Chief Justice Roberts voted as he did. The court was asked to decide if the individual mandate violates the Commerce Clause. The Commerce Clause allows Congress to regulate activity that crosses state lines. Opponents of healthcare reform argued that Congress could not regulate inactivity. In other words, they argued that Congress's attempt to force Americans to buy something was unconstitutional. The initial portion of the Supreme Court's ruling decided that the individual mandate in fact did exceed Congress's authority. Both CNN and Fox News jumped to the conclusion in its reporting that the individual mandate was struck down. As the remaining portion of the opinion was read, we learned that the individual mandate was upheld on the premise that it was a tax. If an individual does not buy health insurance beginning in 2014, a tax will be imposed. In light of this distinction, healthcare reform survives. Healthcare reform also includes a provision which expands Medicaid eligibility. Initially, states that did not comply with this provision of healthcare reform would lose federal funds they already received to help offset the cost of providing Medicaid benefits. The Supreme Court ruled that the federal government could not take away federal funds that states had already been receiving for years. Instead, the government could provide states that expand Medicaid eligibility with additional funds. In light of the court's ruling, neither the Anti-Injunction Act nor the issue of severability were key to the decision. So the immediate impact. Pursuant to the medical loss ratio provision, which went into effect at the beginning of this year, insurance carriers will begin sending out checks next month totaling nearly $1.1 billion. While the amount of regulatory guidance surrounding healthcare reform has been overwhelming, several provisions within healthcare reform have actually been delayed due to lack of guidance. In essence, the regulatory agencies, such as HHS and the Department of Labor, could not release guidance fast enough to meet the aggressive implementation schedule set for healthcare reform. In light of the court's ruling, we can expect even more regulatory guidance to be released in support of implementation of healthcare reform. Many states that have taken a wait-and-see approach to dedicating the time and money needed to establish their exchange will now be taking efforts to implement those exchanges. Those exchanges are required to be set up no later than January 1st, 2014. Is the future of healthcare reform certain? It's too soon to tell. While the court's decision makes it unlikely that the healthcare reform will be repealed, we expect the debate to continue. Mitt Romney has promised to repeal healthcare reform if elected president. We expect healthcare reform to continue to be a hot topic of debate during the presidential elections. It's also likely that candidates running for state offices this fall will be discussing how they would vote if there was yet another attempt to repeal healthcare reform. The House of Representatives is expected to take a vote. Although it may pass, it is unlikely that the Senate will also take a vote. Without a 2/3 agreement between the House and the Senate, healthcare reform will remain the law. So your next steps. So for now, healthcare reform is here to stay. Many experts and surveys show that many Americans do not understand healthcare reform. In light of the size of the law and the many moving parts, it shouldn't surprise anyone that healthcare reform is confusing. Whether you're a business owner, a taxpayer, or both, take time to understand the issues and how healthcare reform will impact our country. While we have heard a lot about the removal of lifetime maximums, the elimination of pre-existing conditions, and other provisions which make coverage more generous, many Americans understand little about the cost of these changes. Even with the changes that have already taken place, health insurance premiums will continue to rise. Employers that have long-term employee benefit strategies in place should continue to refine those plans to make them adjust to our ever-changing healthcare industry. For employers who have taken a wait-and-see approach, now is the time to embrace the fact that healthcare reform is going to continue to impact your business. H&I has been working with its clients to evaluate the decision to pay or play. Either way, employers should follow through on a well-thought-out path with the help of their insurance advisors. H&I is committed to driving change through education, both for our team members and our clients. Visit hni.com to learn more about how H&I can help you understand the Supreme Court ruling and plan for changes healthcare reform will bring to your business.